I only have one question to ask.
Yes.
I'm asking for a friend, though. She has a 19-year-old daughter. She recently got married before the child turned 18. She's thinking about putting in, her husband, I should say, thinking about petition for the child. So I'm wondering if it can work. In fact, I researched it and they said that if the marriage was done before she turned 18, it can work. But I guess she consulted a lawyer. The lawyer is saying that it can work. So I don't know.
So the husband, who's a U.S. citizen, married the daughter before she was 18 years. Married the mother before the daughter was 18 years old. So
yes.
That establishes a step-parent relationship. So now the relationship is established. If the you're a stepfather of this child because the marriage happened before 18. So now,
no, sorry, my bad. The child happened the marriage happened after the child turned 18.
So if the marriage happened after the child turned 18, then there was no step-parent relationship that was established. And then that lawyer is correct. It's because there's no step-parent relationship that's established, a step-parent can't file for a stepchild. The concept is this. You have to have a relationship under the Immigration and Nationality Act to file for a child. So that relationship would be a biological mother, a biological father, a step-parent, or an adopted parent. And all of those relationships between biological parent, step-parent, and adopting parent have their own rules. So for biological parents, you're the biological parent. Go file for your child. For step-parent, you're only a step-parent if the marriage happened before the child turned 18, the marriage to a biological parent, and then for an adopting parent, the adoption has to happen before 16. So in this particular case, no. Now, once the mother gets her green card, even the 2-year green card, then she can turn around and file for her permanent resident, for her child, even as a conditional resident. She doesn't have to wait for the 10-year green card.
Okay then, but this lawyer is telling her otherwise, which I told her to consult someone else to find out, because I know if you pay them, once you pay the money to send it, for instance, she applied and she paid the money, send the application, is that money refundable or it's not refundable?
It's not refundable, and B, you are risking a very high risk of getting put in deportation when the case gets denied. Now the other thing, this child's 19.
This child, she's 19.
Correct?
Yes, she's 19 and 16 to be, I think she's 19, 16 to be 20.
She still lives with the mother?
No, in fact, she's in Jamaica, but the mother is here.
Oh, she's in Jamaica. All right, because I was going to say, if she was here, then we can talk about a SIDG, but she's in Jamaica, no. So what has to happen, she's not going to get deported, you're going to lose the money. This case is going to get denied.
Yes.
That's
okay, and if she's here, because she's pregnant coming up, and if they go ahead and put petition for her, then it's a no case, just the same.
It would be a no case, just the same. Now, did the mother get a green card?
No, she's in the process of getting it. She already applied for a green card and everything, but COVID-19.
Now, hypothetically, I'm going to give you the hypothetical. All right, and you got to read between the lines. Okay, hypothetically, let's assume the mother gets her green card before the child's 21. Okay, and when the mother gets her green card, the child happens to be in the United States legally, has not overstayed the visa, but is in legal status. If the child is under 21, the mother's a lawful resident as of the last year. Priority dates have been current for that particular category. So even as a conditional resident, the mother can put in her adjustment immediately.
Okay.
So, if I was the mother, this is what my advice would be. As soon as I get that visa appointment and I know I'm getting my green card, just by happenstance, hypothetically, just coincidentally, whatever word you want to use, the daughter decides to visit mom. I'm coming to visit mom. Just hypothetical, coming to visit. And by the way, mom's getting her green card next week or in 2 weeks or in 3 weeks. Just coincidence. And she comes to visit. For the intent of visiting. You got to read between the lines. And after she stays here for 90 days, mom has her green card already by then. Mom could turn around and file her adjustment, provided she's under 21 and priority dates remain current.
Okay. I got you.
Got it? All right, good luck.
Thanks, Ben.
Thanks for, I gave you a long one. I know you were like, all right, go, go, go. But you waited so long.
No.
I wanted to make sure you got everything, okay?
I got it, and I definitely need to call you for a consultation.
Wonderful. All right, thanks.
Bye-bye.
Okay. But not for Sandra. That was for Sandra's friend. What do you guys think? All right, let's go to Sheehan in Houston, Texas. Sheehan.
Oh, hi, Brad. How are you?
Hi, how are you?
I'm good. I actually have like a query. I don't know if I should be like worrying about it if it's like a major thingy.
What?
But like I recently got my green card, and they put my middle initial in my actually on my name, but on the machine readable part it has my whole name. So like, should I be worrying about it? Because
they put your middle initial and what? What's the problem?
Yeah. They put my middle initial. It has my first name, my last name, but only my middle initial, which is my actual name, which is Sheehan. Actually, this is what I'm known by actually.
What's your last? So they only have Sheehan, and let's say your middle initial is M. All your green card says is Sheehan M.
No, it actually says Syed S. Ahmed. So like, it omitted the Sheehan. It abbreviated to S. Now I've also read on the internet that it has like a character limitation, because if you go beyond the character limit, then they won't put it on the green card, right?
Your first name's on there?
My first name is on there. My last name is on there. Yes, sir.
Don't worry about it.
Okay, yeah, but the machine readable part has my entire name, so like I shouldn't be worrying about it. But I was like concerned about it.
Don't worry about it. You have a very long name. They can't fit it on the card.
Oh, okay. Alrighty. Thank you so much.
All right.
Have a good day.
Good luck. All right.
Thank you.
All right. Let's go to Natalie on Worcester, Massachusetts. Natalie.
Yes. Hello.
How are you doing?
I'm fine.
What's going on?
Okay. I have 2 questions to ask. Number one, you hear me clear?
I do.
Okay. Thank you. Number one, I came up here on a B2 visa. Literally, I overstayed my visa. Okay, number one.
Right.
Number two, I'm not saying that we can look at it as work. While I was here, my neighbor asked me to hold the kids after school because the nanny was out on vacation.
Okay.
And she paid me.
Okay.
But what I did, I got paid. I applied for my tax ID and I paid my tax from that. It was just for a short period of time.
Okay.
Okay, my problem now is that my dad has petitioned for me. And there are 2 questions that came. The petition was accepted and everything, and I'm asked to send in the I-485, whatever.
Wait, Natalie, let me ask you a question. How old are you?
Yeah.
How old are you?
I'm 40.
Okay. And when did your dad file for you?
My daughter, March. It was a March.
Okay. Just recently filed for you, correct?
Yes.
And your dad's a U.S. citizen?
My daughter is a U.S. citizen.
Oh, your daughter's filing for you. My apologies.
Yes.
You said your dad. Okay.
Yes.
So your daughter is filing for you. All right, let me tell you the rules, because I hear where your concern is. You worked out of status. How's that going to affect everything?
Yes.
Okay, and my answer to you is this. If your daughter, who is a U.S. citizen, she's over 21, she's putting in the adjustment for you, or you're filing your adjustment, your daughter's filing for you, however you want to phrase it, the fact that you worked out of status is not a bar to getting a green card. Under the law, immediate relatives, people who are U.S. citizen daughters, sons filing for their parents, people who are married to U.S. citizens, children under 21 are immediate relatives. The fact that they worked out of status is not a reason to deny a green card. So the answer, the basic answer is tell the truth, because the only way you can be denied your green card is by lying for misrepresentation. So if a question is, did you work? And you say, I never worked, and it turns out you worked, well, now you're looking at misrepresentation issues. But if you say, did you work? And you answer the question honestly, that's not a reason to deny you. So you might as well be honest with a caveat. Okay? No caveat means exception. What the one exception is If your employment was within the first 90 days of your entry into America, that in of itself is a misrepresentation. So you can't be working the first 90 days here.
Okay.
All right?
All right, thank you.
Got it. All right, good luck.
Bye.
All right, let's go to Khalil in Milford, Connecticut. Khalil.
Hello.
Hi, how are you?
Hello, Ben. How are you doing?
Good.
So I have a question that my wife is a U.S. citizen, and I'm on F1 visa. If we file our taxes jointly, and if IRS send us the stimulus payments, will this come under the public charge?
If IRS sends what statement?
Sorry?
What you're on a student visa and you want to file a joint tax return with your wife, and your question was if IRS sends you what? I didn't hear that last part.
Stimulus payment.
A stimulus payment. That is not a public charge. Okay. Now, got to be careful on an F1 visa. If you indicate that you're working as well, then that would invalidate your F1 visa. Although if you're married to a U.S. citizen, it really wouldn't matter.
I'm only working. I'm only working on campus.
Okay, so you're working legally on your student visa. So then, yeah, file a joint tax return. You should, and if you get a stimulus check, and you should get that as well. Bravo for both of you.
So should we return that, or
keep it?
Okay. And second, my question is
it won't affect your immigration. Keep it.
And secondly, I had insurance through Massachusetts Health Connectors last year.
Right.
So, and that in that we got advanced premium tax credit, and Massachusetts is basically a state health insurance marketplace.
Right.
So does getting the advanced premium tax credit 10958 form?
No, I don't. Getting health insurance in a marketplace is not a positive or a negative as far as immigration is concerned. It's nothing.
So it will not negatively hurt.
It will not. It doesn't positively help you, and it doesn't negatively hurt you.
Okay,
if it's Medicaid, that's a different story. But if it's through an exchange, it's not a problem.
Okay, so I had this insurance, and I had already dropped this in last March 2019.
Do you need health insurance right now? It's always good.
I'm on private health insurance.
Then keep your private health insurance. It's better.
Okay, and the last thing is if
the reason why. Let me tell you the reason why private health insurance is better. All right, because I just don't want to say it's better and just throw it out there. The reason it's better is when you fill out the 944 form, and you have to show that you can self-support yourself. Having private insurance is a positive asset on that form. Having the health insurance through an exchange is neither. So it actually helps your case having the private insurance. Also, probably have better health insurance. So for both, that's good.
Okay, so when we will be filling that I-944 form, so will we be saying that we have taken the public benefit in the past by taking the...
That's not a public... No, it's not a public benefit. It's through the exchange.
Okay, some people say to me, you have taken... this will come under public charge or public benefit.
Not the way you describe it to me. Now, I don't know every last... government benefit in all 50 states, because the form does say if you take public benefits that are need-based, meaning that they only give it to people who are below the poverty level, that could be a need-based, below the poverty level government benefit that you took. But based on what you told me, it doesn't sound like it. But if you want to have a consultation with me, we could certainly review it, and I could look up what you're talking about.
And then the last thing, if the F1 students work by chance, by any mistake, so will they, I'm on F1 visa, if one student works more than 20 hours
then you violated your student visa status. But as long as it happened more than 90 days after your last entry into America and you're married to an American citizen, that's unlawful employment, but who cares? You're married to an American citizen. Just file your adjustment. Just like I said the last caller, an immediate relative unlawfully employed, as long as it's not within the first 90 days of the last entry, is fine.
Okay, but like I didn't work like more than 20 hours by myself because when my university...
Khalil, I've just answered all of your questions. We got to get to the next one.
Okay,
But I'm happy to have
you.
a consultation with you. Hold on. All right, let's go to Heather in Trenton, New Jersey. Heather.
Hi, Brad. Thank you so much. Okay, I'm good. I'm losing my mind, so I'll just tell you what's going on.
Right.
So my fiance is detained in Essex County, New Jersey. ICE has him. He had an order of removal and absentia in December 2018. So they first picked him up in December 2017, and he posted bail February 2018. So then in March, he went to Newark, and he did a change of address because someone was threatening his mail. And then 9 months later, his court appearance or his court date came, but he never got anything in the mail. So he was ordered.
Did they mail it to the old address?
The people are saying they didn't get anything. So I mean, we don't have any proof of anything.
We don't know where anything was mailed. All right. And
right. Exactly.
Why was he in deportation?
Well, he came here legally on a visa with his mom when he was 17, and then went to high school, went to 2 years of training, tech school, and didn't really know he was illegal until after, like, he was in his, like, early 20s. And so he just got picked up when he was, like, 25, and
he has
then
no criminal record.
Now when he does have pending cases, but he has no convictions.
What are the pending
cases? And okay, so he kind of threatened me, so he has a terroristic threat, restraining order, and a criminal mischief.
All right, that's it.
And he has another criminal mischief from 2014 and a trespassing. Those are pending. He has court for that on the 30th of this month.
All right, so we have multiple issues here. Okay, let's start.
We want to reopen the order of extension, but here's the thing: we don't have any proof.
All right,
and FOIA takes forever, and they're shipping people out every day, like every other day at 2 a.m.
That is correct. So this is what needs to happen. Okay. At some point, we either have to do a FOIA, or if we don't have time for a FOIA, we just have to make presumptions. Okay. Now, what the law says is this. Okay. The law says they have to give you notice. They have to give you notice of a court hearing. Okay. We have proof that he made a change of address and he never got the notice, right? So what we would need to do is just have to take things on presumptions. Number one, we would have to get an affidavit from the neighbor or the people who are in the house now where he changed his address, saying they live there, they get their mail every day, they never received any notice for a court date for him. Then I don't know, does he have roommates or he lives by himself? He would have to sign an affidavit. I live in this place, I never got anything, and I even put a change of address. So there's a presumption that if something gets put in the mail, it comes to you. But then if you have people saying, I get the mail every day, I never saw anything, that rebuts the presumption that he never received the mail. We don't know where this notice was mailed to. We don't have time, obviously, to find out because he's going to get deported imminently. So we just have to take every possibility and rebut it. It didn't get mailed to the old address. We have an affidavit from that person saying he never got it. Didn't get mailed to this new address. The people who live in this new address, my roommate and me, both sign applications or affidavits, or I just live by myself. I sign it myself. I never received it. I would have been more than happy to show up to court. I didn't receive it. And now you have built a case without getting any file or record anywhere that he never got notice. And if he didn't get notice, then it's a violation of his rights. So that's how I would handle it if everybody's concerned they're going to ship him out at 2 in the morning before anybody gets a FOIA. Right.
Got it.
So,
is it possible? Do you think that we should touch the
now, by the way, after that, yes, you would also ask to have him released because of Corona. He's not a flight risk, and then also we have to figure out how to get rid of this restraining order. He has to be found innocent of any sort of terroristic threat or domestic violence case. And then you have to marry him when he gets out, and then file an adjustment. So there's a lot to do.
Right. What about the Pereira case, the Pereira sessions? Do you think that we should touch on that? Because I know that 72 hours after they're detained, they get a MTA, but it didn't have the time or date on it. So I'm thinking that
I think
we could...
I mean, you can say whatever you want. You can throw everything in.
Leave that alone?
My opinion is he didn't get notice. It's a constitutional violation. Okay, so he knew to show. He knew to show up to court. He was released on bail. So whether to say, oh, because they didn't get, there was some technical difficulty because of Pereira, he should be released. I don't think that's as strong a case arguing some technical, procedural thing as a constitutional violation, which is you're supposed to tell me when and where to show up so I can defend myself. You never did.
Okay, great.
That to me is the
strongest
argument. All right.
Thank you.
All right.
Thank you. Because we had no proof and it's taking forever. Thank you.
You just get affidavit and say it didn't happen. Boom, file it. Because you don't have choices at this point.
Thank you so much. Thank you.
Hold on.
Bye-bye.
All right. Whoop. I guess hold on. All right. Let's go to Eduardo in Oakland, California. Eduardo.
Hi, Brad. How's it going?
How are you?
Good, man. I just have 2 questions for you. The first one is I sent in my I-751 back in February, but I haven't done my biometrics yet. Do you think are they open it soon? Do you think I will be called in for my biometrics, or do you have any update?
Yeah, the update is they're going to use your old biometrics. So as long as you got a receipt notice saying that your green card's extended, they're going to use your old biometrics. They're not going to call you in to do it.
So you don't think I'm going to do a new one for the I-751 this year?
Correct. But as long as you have an extension notice, that means everything's fine.
And can I travel out of the country fine with that notice?
If you have the notice and the expired green card, absolutely you can fly out of the country.
Okay, cool. And second question is, my friend is also in the same situation, but what happened was she sent the I-751 and she did the biometrics and everything, but they're divorcing. And I think the divorce just came out. It's in Florida. So she wants to know.
She has to convert the case to a waiver of the joint application for the I-751 based on the divorce and prove that it was a bona fide marriage up to the time that the divorce started. So she has to do it on her own now.
Okay, but the thing is, her kid, right, I think he's 22. He got his green card, right, through her old husband. But he already got the 10-year one. Right. Does he have to do anything?
Nope. Only she does.
Okay, because he has even traveled out of the country and went back and forth and they never questioned anything.
It's fine.
Huh?
It's fine. They proved it.
Okay. Cool.
All right.
Sounds great, man. Right. Thanks a lot.
You're welcome. All right, let's go to Jose in Philadelphia. Jose.
Hello.
How are you?
Fine, and you?
Good. What's going on?
Well, I have a question about my biometrics appointment. They already I got an appointment for next week, but now I'm scared because my aunt was helping me out fill out the unemployment claims, and she made a mistake because she didn't even ask me. She assumed I was a U.S. citizen, and she marked me as a U.S. citizen. Now she marked me as a U.S. citizen on my unemployment claim.
That's a problem because you made a false claim to U.S. citizenship. Nothing's going to happen at the biometric, but you got a problem with making a false claim to U.S. citizenship. You need a consultation, and you need a private consultation. So hold on one second. Let's go to Joseph in the Bronx. Joseph. Joseph in the Bronx.
Yeah, how are you?
Good, how are you?
I'm doing great. I only have 2 questions. I was able to apply for the VAWA case, and my case was approved. So last year, they send me the prima facie approval of the case with like government assistance for 1 year, so they are able to make a decision on my case. So right now with the pandemic going on right now, I just want to know how the VAWA case or the prima facie case is going on.
How is it going on? They're still processing them. It's good. It may take them 2 years, 2.5 years to go through everybody's cases. They're taking a very, very long time, but eventually you'll get through.
Okay. But and also I apply for the unemployment because every year I renew my working authorization.
Yeah, if you have a work authorization, you can apply for the unemployment. Not a problem.
Okay. Thank you.
Let's go to Marina in Washington. Marina.
Yes.
How are you?
Hello?
Good, how are you?
I'm good. How are you?
Good. What's going on?
Yeah, I have a quick question. I'm studying a bio application in Washington, D.C., and I'm wondering if I can transfer it to Houston.
You could. Why do you want to transfer a case from Washington to Houston?
Because the abuse is just too much. That my abuser is just out of control.
All right.
So thinking that I wanted to.
So you're married to a U.S. citizen. The abuse is out of control. You want to leave the home in Washington, get out of town, get away from this guy, and move to Houston, Texas.
Yes.
Okay.
Because I have a friend that lives there.
You should do that. Now, let me give you some advice.
Okay.
You filed an adjustment application already?
Yes, I have.
Okay. So when you move out, you're never going to go back to this home. You want to move out with all the documents that you can put together and throw in your suitcase to prove you and your husband live together. Because as part of the abuse case that you're going to file, you have to prove that it was a bona fide marriage. And it's going to...
No, I already filed the VAWA.
Did you file it? But again...
Yes.
Are you living with your husband?
No, he doesn't live here, but he has access to where I live.
Oh, okay, fine.
Because he constantly makes threats.
Yeah, so then the answer is go move to Houston and you do an AR-11 and just transfer your address then.
Okay, I can just transfer my address.
Yes.
That's going to be all.
Yeah, AR-11. Correct. That's the answer.
AR-11. Okay. And what are the repercussions of that? Is there going to be any further delay or my process will be pushed back?
Maybe delay a little bit, but I don't think that much. Because it's going to take you 2 years to review your VAWA anyway.
Yes, and another thing that is really crucial is that, I'm working for a friend who pays me, and is that a problem because I haven't received my EAD yet?
No, working out of status as a VAWA applicant is not a problem.
It's not a problem?
No.
So even though I'm on VAWA, so I can continue to work?
Yes.
As long as I don't claim I do any false claims to citizenship.
Correct.
Okay, yeah, because I didn't make any false claims.
So my answer is simple. You're working out of status.
Yes.
You're not working legally. That does not bar you from getting a green card through VAWA.
Okay, so that doesn't bar me from... Oh, thank you so much for your help.
Okay, Marina. Good luck.
Thank you. Bye-bye.
Okay. All right, let's go to Dawin in Arlington, Virginia. Dawin.
Hey, Brad. How are you?
How you doing?
Good. God bless you, by the way.
This is Dwayne. My apologies. Dwayne, how are you? Was this Dwayne or what is your name?
Dwayne. Yeah, DeWitt. Michael, yeah, DeWitt. Yeah, how are you, Brad? I talked to you last time, though. It's been like 4 or 5 months ago, but yeah, I have a question, Brad. My question is, my wife, came from Ethiopia. I sponsor her. I'm a U.S. citizen, and, she has a green card right now, and I'm trying to do a removal condition in the, in the future with you, maybe in June. It's going to be on January, but I was thinking that, because, since, she's receiving, Section 8 house with me and, kind of Medicare, is that going to be issue when she do a removal condition or when she do her citizenship? Because of now, a lot of laws are being changed with the public charge and stuff like that. And I was just worried, my wife worried too.
All right. So who's the U.S. citizen?
I'm the U.S. citizen.
All right. So my answer to you is this. It's not going to affect your wife's green card because the laws changed prospectively for any adjustment applications filed after February of 2020. So your wife had her adjustment and got her green card well before this. So it has no effect because the I-751, they're not questioning whether or not she's a public charge, and on her citizenship, they're not questioning whether she's a public charge. So for her to remove the conditions and to become a citizen, the new public charge rules will have no effect on your wife whatsoever. The only thing you have to worry is that you signed an affidavit of support for her, and she is getting public assistance, and the government can always go after you to get reimbursed for this public assistance. If they do, you would be the unfortunate first person I ever heard that the government went after. I never heard them go after anybody. So, but now Trump threatens that he's going to start going after people, but those so far has all been threats. I've never seen them do it.
Okay, so she can receive a benefit, right? The Section 8 or the Medicare, fine. There's nothing effect on the condition or her citizenship, right?
Right. The only thing she has to worry about, only thing that anyone has to worry about in this scenario is the people who sign the affidavits of support. But as I said, I've never seen the government go after anybody.
Okay, because she has a green card, she's okay.
Correct.
Okay, but so I'm gonna call you on January 1st, you know, to do removal condition. I'm living in Virginia, but you know, I know you the best, and you know, I'll follow you and everything. And all I'm gonna say is God bless you and all your staff members.
I appreciate it. Thank you.
Thank you, man.
All right, let's go to Christine in Houston, Texas. Christine.
Hello?
Hi, how are you?
I have a question.
Yes.
I'm going to know about the DACA if I'm eligible to apply and my siblings.
You can put in new applications now if you've never applied before. You had to be here prior to 2007, June of 2007, been under 16. How old are you now?
I'm 16.
You're 16 now. When did you come to the United States?
Not so long ago, 2018.
Then you would not be eligible for DACA. What you would be eligible for, who do you live with right now?
My mom.
Where's your dad?
He died.
Okay. So what you would be eligible for is a Special Immigrant Juvenile petition to get your green cards.
Special what?
Special Immigrant Juvenile petition.
Okay, how do I go about that?
You would have to go to family court. Somebody would have to get legal guardianship of you and show a family court judge that it's not in your best interest to be returned home because you got no family to go to back home. Your mom's here and your dad passed back home. So you would win that case every day, and then if you get the SIJ and get this special order from a family court judge, you could turn around and apply for your green card. What I would suggest you do is for you and your siblings, you're 16 years old, is have an adult call me and have a consultation, an adult who wants to help you, whether it's your mother or somebody else. And I'll be happy to go through it and explain what to do to get you your green cards.
Okay, can you repeat the first thing you said? The juvenile, whatever?
SIJ, which is Special Immigrant Juvenile.
Okay.
Right, hold on one second.
My mom is not a citizen. We're not citizens.
That's fine. You could be out of status and get legal guardianship of your child and get the SIJ. So we can help you one way or the other, whether it's your mom or somebody else. All right. So hold on one second. Let your mom. You can watch this in perpetuity. So tell your mom to watch this segment later on YouTube or Facebook. Okay.
Okay.
Hold on. Let's go to Mohammed in New Orleans. Mohammed will be our last call of the night. Mohammed.
Hello, bud. How you doing? Good.
What's going on?
My question is, I have been a lawful permanent resident since December 2017 based on spouse abuse, VAWA. And I would like to know when I have to file for citizenship.
You got the green card in 2017?
Yes, sir.
What month?
December 14, 2017.
Okay, and the abuse was through a U.S. citizen? Your wife or your ex-wife was a U.S. citizen?
Yes, sir.
Okay. So 3 years from December 2017 is December 2020. So you can file in December 2020, less 90 days. So right. So sometime in October 2017, you can file for your citizenship.
Okay, but I have been out of the country for couple times for 3 months, 2 months, 2 times, so it's not going to affect.
As long as you were not out for more than 2 or 3 months at a time, and if we were to add up all the time between December 2017 and December 2020, at least 18 of 36 months in the United States, you can become a citizen. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.